Good morning. Good morning, Excellencies, ladies and gentlemen, distinguished guests, and distinguished speakers and moderators. It's a great joy to welcome you again to day 2, an important day to continue our discussions from yesterday. It was off to a terrific start, and we very much look forward to continuing the discussions here today. And I'd like to once again thank you all for being here on a Saturday. We really appreciate for you taking the time, and your presence is greatly valuable to us, and we very much look forward to your contributions all throughout the next 4 panel discussions. Before saying the official thanks at the closing of the ceremony, I would like to once again thank all those who were involved in terms of making this a successful conference and all the hard work and the efforts that have gone into preparing such a conference. And in particular at this stage, I'd also like to particularly thank the International Center for Transitional Justice and personally thank David Tolbert for all the efforts in preparing and laying the groundwork over all the summer months in putting together the various panels. And so we are very grateful for that cooperation and that relationship with the International Center for Transitional Justice. Now it's my pleasure to hand you over to our panel 5, which is entitled Development in the Service of Transitional Justice, and hand over to Eduardo Toledo as the moderator, who's our Senior Officer for International Criminal Law at the Nuremberg Academy. And I'd like to use this opportunity also to thank him for all the hard work in preparing the conference throughout the last few months. Wish you all a wonderful day 2, and we look forward to all the discussions. Thank you.
Thank you, Viviana. It's an honor for me to be seated here today. It's an honor for me to moderate this panel with these distinguished colleagues. And of course, it's an honor to moderate one panel of a program that we developed within the Academy since May. We are here to discuss about development in the service of transitional justice. As you may know, in the Declaration on Peace and Justice, that's part of the 4th part. It means recommendations, and in the 3rd part within recommendations. The first paragraph says something that is important here. It's conflict often results from the lack of social justice. Addressing root causes of conflict and supporting access to public goods and services, economic resources and opportunity is in a non-discriminatory and equitable manner are critical part of peace building and development programs. Special attention should be given to those most affected by the conflict. My dear colleagues, here today will present how we can tackle that and how we can use new tools to shape paradigms of the past. And of course, how we can address crises in post-conflict societies. First, we will have Marieke Wierda. She is a Dutch lawyer, and she's in her current capacity as a rule of law coordinator for the Dutch Ministry of Foreign Affairs. She's involved in discussion about hybrid tribunals in Central Africa, America, and South Sudan. Then we will have Christopher Mahony. He is a research fellow at the Center for International Law and Research and Policy. And finally, we will have Samuel Lemonet, a Swiss lawyer working for Rapid Response, Justice Rapid Response. So, Ms. Wierda, please.
Thank you very much. It's my particular pleasure to be here, and I want to thank the Nuremberg Academy for their invitation, because I was actually quite involved in the conference 10 years ago, and that gives me a particular perspective. I was trying to figure out whether some of the pessimism out of the current situation comes from the fact that I used to be civil society, so maybe inherently more optimistic, and now I'm working in government, and so now the realities confront us. But what I wanted to do this morning actually is not be pessimistic. What I wanted to do is 2 things. One is reflect very briefly on the challenges that we face 10 years on from the last Nuremberg, but speaking more from a government perspective. And then secondly, I wanted to kind of make a pitch And my pitch would be that we need to revitalize a bit this justice agenda. And there, I think we can actually learn valuable things from the development field. I'm working mostly as a rule of law specialist, and I actually mostly work on domestic contexts now. But I think there's quite a few things we can take from there that can help us to revitalize the justice agenda and to, in a sense, to breathe new life into our quest to build a future, which was our ambition in 2007. Now we're just talking about the crossroads. But I would say we should try to continue to build a future. So very briefly on the setting the scene, and just speaking honestly from the perspective of being inside the Dutch government. I mean, one challenge has already been mentioned, but we face more conflicts now than ever since the end of the Cold War. And what this does in practice, particularly in government, is that we are torn in many directions. Our attention is constantly occupied, and very often by the current events, if you will. We face, of course, enormous challenges, many of which are of a cross-border nature, including terrorism, migration, climate change. And this sense of competing demands raises a lot of urgency. Now is the time when humanitarian crises are at an all-time high, with 65 million IDPs worldwide, 20 million refugees. So humanitarian demands are enormous, but at the same time, we face, in many of our countries, a restrictive political climate. The public support for development assistance and for interventions abroad has gone down in our own societies. People prefer for taxpayers' money to be spent on issues that are more directly linked to national interests. And so we're constantly facing pressure from our parliaments and being asked in detail about our interventions. And in general, I think as international donors, we've become less ambitious than we were 10 years ago. 10 years ago, we were involved in Afghanistan, Iraq, all these were state-building projects, so they were often phrased in those terms. We don't use that terminology much anymore. Now we're using a terminology of stabilization. And stabilization is a much more humble concept. It has different interpretations between different donors, and in the Netherlands we still talk about legitimate stability, which we consider to be a bit different from some other kinds of stability. But in this context also then, it's in a sense not entirely surprising that we find this kind of crisis of the rule of law, or we see how it's ebbed a little bit from where it was 10 years ago, with the widespread disrespect for international humanitarian law in conflicts all around us, also the attacks on the International Criminal Court, but also a sense of skepticism, even about transitional justice. I think there's people are asking, does this concept actually work? Because we've been doing that for a while, but at the same time, we actually see an increase in conflict around us and a decrease in stability. So how do we know that our interventions are working? So having said all that, revitalizing the justice agenda, I think there are two aspects to this that I would want to stress this morning. One of them is about learning and adaptation in order to increase our effectiveness. And the other one is about innovation, accepting new concepts, new models, and in a sense facing this problem of scale as compared to limited resources. I think that problem forces us to innovate. And in a sense we can learn, I think, from our colleagues in the humanitarian field, who are also increasingly innovative, and in particular in three areas, i.e. in the use of big data, to know more about their interventions, in the use of technology, and also in financing and finding alternative ways of financing interventions. But I will talk very briefly about the rule of law field, because I think we've been under constant pressure, in a sense, to measure our effectiveness, because in a sense, rule of law interventions historically haven't usually been very, very successful. And sometimes one is a bit hard-pressed to say, oh, these countries made real progress in rule of law through international development assistance in the last few decades. There are some, but there are not too many. And I think this has pushed us to do a few things. First, we have to be very clear about our assumptions. And in the development field, the way we identify our assumptions about our interventions is we often draft a theory of change. How do we think we will bring change to a context? For that, it's very important to know the context and to do political economy analysis or to understand the environment in which you're working. And then, of course, you want to use an evidence-based approach to test your assumptions. And if your assumptions are mistaken, then you want to adapt. And the way this has worked in rule of law is, for the first generation, many interventions were rather top-down. They were about redrafting laws, about building infrastructure, courtrooms, prisons, and about training judges or legal professionals. But in the rule of law field, we came to realize, I think, that often in many of these societies, we can actually reinforce absence of rule of law by a very top-down approach, because in many countries, really corrupt elites, to be frank, are using state structures as means of oppression. And so if you focus your interventions top-down, you may be, unfortunately, reinforcing some of those power structures. So in order to tackle that differently in the rule of law field, the second generation, there's much more recognition that you need to change a culture. And you need to, in a sense, try to improve the lives of ordinary people by tackling the problems that they face. And this requires a much more bottom-up approach. It's more access on more emphasis on legal empowerment, access to justice, etc. And those are also the concepts you see back in Goal 16, for instance. Data is an important part of this. Where do people concretely go to resolve their legal problems? We need to know those things in order to intervene effectively. And you may ask yourself, what's the application to international criminal law or to transitional justice? I think to transitional justice there is a very broad application, and much of it would be the same. But even in international criminal law, I think we need to really ask more questions about our assumptions. Is deterrence our assumption, and what is the empirical evidence? If it's not that, is it more prevention? The World Bank, of course, has been working on prevention from an empirical perspective the last year. We need that kind of evidence to calibrate our interventions, and we need to, I think, be open to adaptation based on effectiveness. Then on innovation, very, very briefly, here, just to make a bit of a pitch for sustainable development goals, because I think they give us something new to revitalize this agenda. Three things they give us that are new is there is a renewed political focus, but within a kind of a universality context, so that all states are equal. We all have to apply SDG 16, and it raises challenges for all of us. Secondly, there's this emphasis on measurement, knowledge, and data collection. So if we measure the number of violent deaths in a society, and we manage to reduce that number, it will tell us something, I think, that we need to know. And thirdly, and maybe most importantly, it forces us into unconventional partnerships. Because I think we're so often talking to the like-minded, and not even that, sometimes we're even in silos amongst ourselves. ICL practitioners are different from transitional justice practitioners, are different from rule of law practitioners. We need to, I think, look a little bit broader, because in the end, if we are to try to achieve results in peace and justice, we really need to work cross-disciplinary and learn from each other. Innovation also entails, I think, looking at new models. And here, I think, to give credit to the field, we do see a lot of innovation. In Colombia, with the peace accords, the combination between peace, political participation, and punishment, I think, is very unique. In Tunisia, they're trying to expand transitional justice to corruption. In Central African Republic, they have a very, very innovative new model of a hybrid court. And also the IIIM created for Syria, I think is an innovation which could potentially help us to use domestic jurisdictions more effectively to fight these crimes. And we need to, I think, keep innovating. We need to ask ourselves, and it came up briefly yesterday, for instance, about the application of lessons from transitional justice to dealing with extremist groups. We know we shouldn't deal with all of them through a criminal justice model. So I think it's a challenge for all of us. We're called on to, in a sense, rise up to the plate and to up our game, if you will. But I am hopeful that we can accomplish that. And that in 2027, at the next Nuremberg conference, I hope we can reflect on some of the progress that we've been able to make.
Thank you very much for your nice introduction and very broad. That leads us to the next subject, that it's the intervention of my colleague Christoph Mahony. And I would like to highlight one thing that we said last night during the organization of this panel. Today we have the tools to understand if we are doing right or wrong. We can collect the data and we can change our path. That was not that easy a few years ago, but that's important because 10 years ago, those that wrote this declaration said it. Transitional justice mechanisms and development effort have a specific and distinct roles, which should be complement each other and be integrated into a comprehensive peace-building strategies. That's exactly what my colleague here will present more or less, and we will see what we can have in the future in the field. Thank you.
Thank you, Eduardo. Thank you to the Nuremberg Principles Academy for the special privilege of participating in this event and, of course, to speak on this panel with distinguished colleagues. I should firstly make clear that I speak in my capacity as a research fellow for the Center for International Law, Research and Policy. My remarks do not reflect the positions, policies, formally or informally, of the World Bank or the United Nations Development Program. However, I will refer to some of the work that we are doing. I'll actually draw to some extent on the remarks of our colleague Marieke just now, where she referred firstly to Sustainable Development Goal 16. This is particularly pertinent in these post-conflict situations where international criminal law commonly intersects, although of course we see it increasingly during conflict as well. And what it tells us is about the interdependence, right, of inclusivity, justice, and sustainable peace, right? And it's the inclusivity of justice, and what that means is the non-discriminatory nature of justice. And I believe Eduardo mentioned that in referring to the principles in his opening remarks. It also tells us much about the issue that Marieke highlighted, this problem of an emphasis on stabilization, on short-term issues, on short-term responses, and on short-term objectives, right? That is quite different from what we call prevention, right? And that is the fostering of inclusive, just, and peaceful societies in order to prevent the outbreak, escalation, or recurrence of violent conflict. And so, as part of my day job, I've also been working on this joint United Nations World Bank report on conflict prevention. And I think Marieke referenced a background study that we did, which is specifically on transitional justice, but the broader report, presented to the United Nations General Assembly by the World Bank President and the UN Secretary General a few weeks ago, emphasizes this issue about grievance rather than greed as the primary driver or enabler of violent conflict, right? And what we in our field don't necessarily think enough about, in my humble opinion, is the extent to which criminal justice processes can mitigate or, in fact, deepen these grievances, depending on the extent to which, either objectively or perceptibly, whether they discriminate against one social group or not, right? Whether they objectively apply law to fact in an equitable way, or whether there are particular social groups either at the local, regional, or international level that shape these processes to direct them at particular social groups and away from others. And so what I'll focus upon is the extent to which development can manage and mitigate the extent to which at least domestic processes can mitigate rather than deepen what we call horizontal inequalities of criminal justice processes in response to core international crimes cases. And to do that, of course, we need to look at the different elements that drive discrimination in international crimes prosecutions. Right? And there, of course, we need to look at the totality of offending. What does the data tell us? And Marieke mentioned, the empowering nature of having data and our capacity now to collect it, to vet it, and then to enable it either by for practitioners to inform equitable approaches to who they pursue and who they don't, but also to civil society to better scrutinize these processes. So, of course, you have the jurisdictional elements. We have, in terms of where things conduct had to have taken place, when, by whom, what, and then, of course, the functional elements. Who finances these things? Who gets to select the prosecutors? Who has to or does not have to, and does or does not cooperate in terms of access to territory, access to witnesses, protection of witnesses, access to other forms of evidence. And so what I'll focus on today is one inequality mitigating instrument that the Center for International Law Research and Policy has been developing. It's the Case Matrix Network, which some of you may already be familiar with. It exists already, and soon, either later this year or early next year, we will be launching Nexodus. So for those of you familiar with the Center for International Law Research and Policy, we hope you have attended some of our programs in the past. We're mostly well known for these conferences and these research outputs, right? But we're increasingly going beyond this to try to manage and mitigate the inequality of arms, not just between different states and their capacity to prosecute core international crimes cases, not just between different social groups that may obviously represent more commonly victims from within their groups, but also the civil societies within these situations so that they can more effectively scrutinize these processes and bridge this gap, right, between the what might be objectively discriminatory or not, and what is perceived to be discriminatory or not, right? Because in terms of the extent to which horizontal inequality drives conflict, it's how social groups perceive the extent to which they are marginalized or not that informs the extent to which they might be mobilized to violence. So these are the key entities we have here at present. And of course, I'm going to focus on this case matrix network. And it focuses on both gross human rights violations as well as core international crimes. And those of you engaged with the International Criminal Court in particular will be familiar with the ICC Legal Tools project. We have the databases. These are increasingly blue linked by topic, so that this inequality of those familiar with and with access to judgments can go direct to the specific text within a judgment that is pertinent to a particular, for example, element of a mens rea or actus reus element of a crime. And then, of course, we have these publications that we've been producing for a number of years now. And we're increasingly introducing this competence of capacity building. And what we're doing is ensuring that these instruments are sort of adapted to different working languages. If you go to our site, you'll see that we're already trying to bridge this east-west divide. Right? Our director is, although Norwegian, is also professor of law at Peking University. Just a couple of months ago, we had our second or third, I believe, conference in Delhi. The data on the site is in Chinese and Indian languages also. We customize also to specific legal frameworks in specific contexts, of course, in order to make the data, to make the tools more accessible to users. And that accessibility is, of course, informed by cost as well, right? And so we make this available free of cost, not just to the end beneficiaries, but also to any intermediary actors that we might work with. And those intermediary actors we also support through mentoring and the use of the various tools. One of which will, of course, be this investigation and fact-finding toolkit that we have developed, a case mapping, selection and prioritization toolkit, a case analysis toolkit, and then for the more diplomatically oriented, a ratification toolkit. And of course, these all derive from many conferences, not unlike this, where we have brought the leading expertise in the world together. Many of you have participated on these specific thematic issues, right? So that we're able to draw on a diversity of knowledge. Obviously, what is perceived to be the leading actors in the field, but also actors more specific to the context in which we work, right? So it's not just those in international criminal law per se, but also development actors in the field. Next weekend, for example, the United Nations Development Program will be co-sponsoring our event in Florence, and the head of peace building and governance in New York will be opening the conference. So this context specificity allows us, for example, to dive into particular contexts, to identify the leading actors, their competencies, and then tailor the training on these toolkits to those specificities. And I believe I have time, my friend.
Yeah.
Uh-huh. So.
First one with
okay.
3 minutes.
Okay. So let me just skip through just to give you a visual of what this might look like. So and the multiplicity of of methods used simultaneously. So, for example, the Rome Statute, right? You'll be able to go through the Rome Statute, go into any particular article, go element by element, and have not just the specific explanations, all the key decisions linked directly back, blue linked, but also the video explanations from many of the leading scholars. You go to the site, you'll see you'll see much of this already there, but we hope to be launching this very soon. I was out of time some time ago. I apologize.
Thank you, Chris. Sorry to interrupt you, but coming from Argentina, it's easy to say that these kind of tools could be excellent for the South in particular. If you need to buy the book of one of the book of Cayambos at £450, plus somebody could take it for you, or you pay 100 more to somebody at those wonderful private companies to send it to your house. It's kind of far, and it's not only geographically far. It's that you cannot afford it. It's clear. You need to download in PDF in one of those weird places. And it's not a justification, but it's true that we need access to all of these kind of things to know what it's really happened here, or in The Hague, or in the tribunals in general. So that leads us to the last intervention. That again, I would like to quote the declaration. The last paragraph says that national and international development actors should be sensitive in dealing with the past when designing post-conflict development strategies, and take into account relevant recommendations of accountability mechanisms. That's what Just Rapid Response do in a way too, and that's the way that they address these kind of issues directly with some governments. So please, Samuel, can you?
Eduardo, thank you very much. I'm very honored as well to be speaking today, and thank you for the invitation. Thank you for having me on that panel. I will speak about a different tool and initiative that has been also developed over the past 10 years, and this is namely the organization for which I'm working, Justice Rapid Response. I will cover 3 topics during my short presentation. The first one, I will try to give you a brief update and overview of why Justice Rapid Response has been established and how it's working today. It's going to be brief. The second one, I'm going to more specifically discuss the way we are able to support, in some situation, domestic jurisdiction that are prosecuting and investigating international core crimes. I'm going to call this, for simplification, our complementarity program with reference to the Rome statutes. And finally, I will also briefly discuss, because this is also the topic of that panel, the link between accountability, criminal justice, and development, and see how these 2 things can complement and help each other. And I will submit this to the discussion of the panel and the room as well. Well, just briefly about Justice Rapid Response. It was created by a group of states supporting the idea that fighting impunity for international core crimes depended on the capacity to conduct prompt, thorough, professional investigation. Without credible investigation, justice cannot be done regardless of the effort and the resource that you put in the rest of the process. And this was the idea that started Justice Rapid Response. To achieve that goal, Justice Rapid Response has created and is currently managing a specialized standby roster of human rights and international criminal justice experts, as well as a mechanism to deploy them rapidly in situations where they are needed. I'm very glad to say that in that room, and I realized this by talking to a number of persons yesterday, there are a number of early supporters of Justice Rapid Response, and there are also a number of experts which are actually on Justice Rapid Response roster, and I would like to thank both of them because they are making us who we are today, and they are available for rapid deployment, and this is really something that we appreciate. Just to give you an idea of the tool that we have been creating, the roster itself, it is currently composed of 650 criminal justice experts. They have been carefully selected. They are coming from 110 countries and speak altogether 90 different languages. One very important element of that roster is that more than 40% of the experts there are themselves coming from countries in transition, countries that have experienced armed conflict themselves, and the roster is also gender balanced with about 55% of experts being female. And this diversity, both geographically and in terms of gender, is absolutely key to be able to deploy the right person at the right time in the right place. I will come back to this a bit later. In terms of competence that we have there, we are covering more than 50 different disciplines, all of them being at some stage useful within the framework of an international investigation or an investigation of international crimes. Let me give just a few examples. We have military analysts, we have investigators, prosecutors, forensic anthropologists, forensic pathologists, witness protection experts, and that's the kind of competence that we can pull from the roster and deploy rapidly where it's needed. I don't have the time today to give you all the detail about how we onboard or we certify people on that roster and what are the criteria for deployment, but I'm available to answer questions, and I'm available to answer questions during the coffee break as well. What I would like to emphasize is just to give you a sense of what type of missions we have been doing since we became operational in 2009. Out of 126 missions that we have done so far, and through this we have deployed about 190 experts, we have been able to assist investigation by international courts like the International Criminal Court, by the work of hybrid tribunal like the Extraordinary African Chambers, but also the work of investigative mechanisms that have been set up by the UN or by the African Union, such as commissions of inquiries, fact-finding missions. That's the type of mission we have been deploying in majority. And many of them, and this is also a concrete example of the contribution that we have made, have been able to enhance the quality of investigation in specific areas, such as sexual and gender-based violence crime, because based on a partnership we have established with UN Women in 2012, we have been able to develop on that roster a specific investigative expertise in investigative such crimes, which are indeed really specific and require a specialized approach. Of course, the second part of my presentation is about how we can support states using their domestic jurisdiction to investigate and prosecute international crimes. And I will use an example to do this. And this example is Guatemala. We have been working in Guatemala since 2015, and we have been collaborating with the Office of the General Prosecutor. The initial mission was there in 2015, was deployed in partnership with UN Women, and we have deployed prosecution experts specialized in sexual and gender-based violence upon the request of the Office of the Prosecutor there, to see and develop an approach to prosecute sexual and gender-based violence crimes which had happened during the period of the armed conflict there. And during this first consultation mission, our expert has gathered a number of requests and needs that were expressed directly by the Fiscalia, the Office of the Prosecutors. On this basis, in the following 8 months, we have been able to deploy 2 follow-up missions in December 2015 and January 2016 to strengthen the capacity of the Ministerio Público in areas beyond sexual and gender-based violence. The experts deployed, just to give you a sense of that, were a senior prosecution expert, an intelligence analyst, and a legal advisor with extensive experience in litigation. And the role of these experts was to provide case-based technical assistance and mentoring work working with the prosecutors. And the team also provided mentoring on investigation techniques, evidence gathering, and prioritization of investigative tasks with a special focus, again, on sexual and gender-based violence crimes. In this regard, Guatemala is a good example of the way we would like to work with the national authorities. It is a context where the local authorities have taken the investigation and prosecution of international crime into their own hands, and the merit is really theirs. They have asked for support when this was required and needed, and have begun the process of achieving accountability for these crimes. These prosecutions, in particular against members of the military, resulted early in 2016 in historic conviction for past human rights abuse, including SGBV. And don't take me wrong, this is a long work that has many people have contributed to it, but we have made that small contribution that I've presented to you. There are 3 points I would like to emphasize about this approach and this way of working that I think are relevant for today's discussion. First, because of the diversity on the roster, we are able to deploy experts which have themselves experienced situations of conflict and post-conflict situation, and this helps create this link because they know the type of obstacles that they are going to face when they will work together with their counterpart in the situation country. The second point is it is useless in such a program to try to impose a rhythm to its counterpart. When you are working on a mentoring format like the one I described, the rhythm is dictated by the prosecutors locally, and this requires also a capacity when the opportunity is there and when the request is there, you need to be able to deploy that person at the right moment. And thanks to the flexibility of the mechanism of Justice Rapid Response roster, this is something we can deliver with the caveat that we need to have the funding to do so. In some circumstances, this is what is delaying follow-up missions and support. And the last point I wanted to make is that the succession of short missions, like I described, has the advantage of keeping the ownership at the local level. And very often you realize that between missions, prosecutors supporting other prosecutors locally will exchange information, questions in between missions. And when you see that happening, you know that you have realized this individual sort of relation and peer-to-peer support. Of course, not everything is perfect, and that's a very challenging process because it requires a number of conditions to work. And I will just finish on this, and I think this is going to make the link to the development sector. You cannot engage in such a program if there is not a quite clearly expressed political will to work and investigate those cases. This is probably the most important and the most difficult condition to assess before going and deploying experts like I just mentioned. And the two other elements are also quite important. You won't develop such a program in a place where there is not a legal framework that allows you to work and prosecute those crimes, and you would not deploy such a program in a place where you have no institutions, no legal institution or judiciary institution, because you cannot work on that program in a vacuum, right? And then you need to assess these conditions, and very often, and I will finish on this because I see that the time is short, criminal justice or justice sector reform that are driven by development actors, they are precisely working on these conditions, right? Legal framework, capacity building in the form of training, strengthening institutions. I believe that the program that I just presented and this complementarity work can come together at some stage with this deployment work to bring in an element of result and visible achievements to an otherwise broader justice sector reform process. Because if you manage with this case-based approach, peer-to-peer support, to get some accountability that is visible to the population, I think the confidence in institutions can be built as well, and this is contributing directly to take this situation on the path of development. I'm not saying this is always the case. I heard yesterday the different challenges and paradigms that are there when you are working. There is not one society, there are many groups. It's really a fine analysis that you need to make. The kind of tools that Chris has presented can probably help in that regard, but I strongly believe that the flexible approach that I've presented can achieve something if it's combined with other initiatives like the one of Chris or complementary to development work. Thank you very much.
Thank you, Samuel. Thank you for your presentation. I think you work also in this path to eliminate discrimination or differences at the national levels, because there is a lack of capacity with wonderful professionals with no money to address the issues. So it's a great thing that you are doing there. I would like to highlight that you used an expression that I like. It's political vacuum, that in my perspective it doesn't exist. It's not possible, even if we want to believe on that. We are always working in political environments. Society it's a political element, and we need to understand what to do when we get into this situation, how we can address to these conflicts. So before we move to the questions from the public, I would like to, I see a hand already, but I will ask my question first. I have some powers as the moderator here. One person that was important also for this program since I came to Nuremberg was Christian Much. We worked together also in this program, and we had many discussions during the process. And one in particular, it's the question that I will address to you too. And I told you last night, so don't put those faces that you don't know what I'm going to say. Last week, Oxford published an article called More Than Misfortune, Recognizing Natural Disaster as a Concern for Transitional Justice, written by Megan Bradley. I encourage you, all of you, to read it. It's a good piece. And in the conclusion, she says that disaster might involve intentional abuses as well as injustices, in which natural hazards, structural injustice, negligence, discrimination, and other purposeful violation are entangled to varying degrees. She tried to understand which elements from the transitional justice could be applied to address the issue of a crisis in the aftermath of a natural disaster. I will include the natural disaster itself and also those that are part of the negligence of a company. For example, the typical example is the destruction of a dam. We have in Brazil a great example from 2 years ago. Two questions. First, do you think that we can use these elements? And in the case that you think so, which one?
We did talk about this last night, but I have to confess offhand, I did not then go and stay up all night to read this article, so maybe I should have. So that's a disclaimer. It's an interesting question, and I want to preface what I would say with this comment you made about the political. And this is really something to stress. All the contexts in which we act are very political. And I think as development actors, we are now very aware that our interventions are not technical, but that we need to understand political context. In terms of natural disasters, however, I think we need to look quite carefully at what they are, because I do have to say sometimes we forget a little bit about our colleagues who do humanitarian work. And the issue with humanitarian interventions is that they're guided by humanitarian principles, and those principles are completely divorced from development or those kinds of interventions, in that they have to be explicitly not political. So they have to be completely neutral and impartial, and have to treat all the people affected by natural disaster in the same way. And I believe that's for very good reasons. I think now in today's conflicts we're facing a number of very difficult situations where that line sometimes becomes blurred. I'm thinking, for instance, of Yemen. The Saudi government has a big humanitarian agency delivering relief. Is that, how does that fit in the spectrum? These are very difficult questions, but we have to guard that humanitarian space, first of all. But then secondly, of course, there are situations in which there are links with criminal behavior. All the 4 famines that we face right now in Yemen, Somalia, Nigeria, and what's the 4th one? It's escaping me right now. South Sudan. are all man-made famines. And take that a step further, of course, in many other contexts, Colombia being one, the mining industry in Colombia has long maintained links with paramilitary groups that have victimized members of local communities. And the question now is, for instance, what could be the liability of those third parties, i.e. business, under the transitional justice system? I think those are relevant questions. And I do think transitional justice can apply, but I think we have to, again, balance imperatives. We need to, from a development perspective, and SDG 16 stresses inclusiveness, not leaving anybody behind. At the same time, we need to, in some situations, acknowledge that some groups or individuals have suffered harms due to intentional acts, and they need that recognition, they need reparation. But we need to, in a sense, maintain a balance, because otherwise we end up enforcing those horizontal grievances that Chris talked about.
Chris, do you want to add something?
I would probably just re-emphasize this issue of the horizontal grievances. I think for some time now, like Marieke mentioned, we've acknowledged and begun to explore not just the fact that we engage in, in variant contexts with variant political interests, but go further to the how, right? And that's where we have to roll up our sleeves and, and go beyond the theory and the acknowledgement. And that comes back to how long-standing are our local relationships, how representative are they, right? And there's an interaction between that and these horizontal grievances, right? Because what we often find in these various contexts is civil society actors are often self-selecting, right? And the extent, the longevity of our pre-existence on the ground, and this is where UNDP is very well positioned because it is the most long-standing actor in almost all these situations, is the fact that we have the pre-existing relationships with this, not just government, but also civil society. So we understand the authenticity of the representativeness of the people that purport to act for different social groups in society, right? And that's very important because that contextual understanding is critical to understanding then how our engagement will either deepen or mitigate these intergroup tensions. And that's really important for how we respond to a natural disaster, right? Because a natural disaster is not really a transitional justice issue, but it can be a shock that triggers these group-specific grievances that a nefarious actor might see as politically advantageous to mobilize to violence. So our responsibility is in preventing, right? So it's, does transitional justice go to the drivers of conflict sufficiently? That's a long-standing critique of the field, and I think a well-merited one. And it can go even further to say, to what extent do we not just address the drivers of conflict, but also respond to those drivers before conflict starts?
So I will open the floor for questions. We already had one here. We will collect a few questions and then answer. Thank you.
Okay, thank you. My question is to Mr. Mahony. In September, we attended conference in Ukraine, international conference in Ukraine in Odessa. And I was approached by the young lawyers from prosecutor office in Kiev. And they needed help of training of this kind of crimes. They have many difficulties. They are looking more to the prosecutor office of ICC. But my question is, what you would recommend to do regarding your organization? How to approach funding and other things? Thank you.
Joachim Fritz is my name. I'm from GIZ, German Agency for International Cooperation, and I'm heading the division of governance and conflict, and we're here together with my colleague Ms. Ritala, and we would first of all like to congratulate the Academy for picking up this important panel on the linkage between development, stabilization and peace building. So I think here we have really hit or starting to hit the nail on its head, because I think this interdependence is the most or the biggest challenge for laying ahead of us. And I would like to build up my question with two remarks. The first of all is I particularly agree with Ms. Wierda from the Dutch Foreign Affairs, because the German government has recently published a new guideline on crisis prevention, conflict management and peace building in June of this year. And what was new about this guideline is that it was first of all jointly developed between three of our most important ministries in this field: Ministry of Development, Cooperation, Foreign Affairs and Ministry of Defense. So a first lesson learned is, compared to 10 years ago, we have now three ministries talking to each other about this important agenda. So the interconnectedness of development, stabilization and peace building is maybe in theory evident, but it is not in practice. So here we are advancing. And the advancement of this guideline on the second part is the German government identified 5 areas of intervention, or intervention is maybe not a very good word, of support, or how the issue can be dealt with. And this is legitimate policies, and this is going to be my first question to you, Ms. Wierda. What is your understanding of this concept of legitimate stabilization? Second one is security, and reviving a little bit the concept of human security. Very important to live free of fear and live free as well, and have the access to services. Third one is rule of law. Fourth one is economic development, social cohesion and natural resource governance, because this is a very precise one of the drivers, I think, for many of the conflictive situations. And the last one is very interesting because it is about domestic resource mobilization. It is about the public finance field. And here you see probably something, from my perspective, very new in the agenda: how to build connectivity between a national tax system, for example, and its implication on conflict drivers, or on creating stability and equality in a country. So my second remark, building to the question, is on the Agenda 2030, which is for us in the development cooperation world one of the most important agendas we have currently, because we see two great potentials. First of all, the principle you mentioned, universality, which I think gives us a new ground for cooperation. And with regard to what Samuel said on political commitment, I think here we have an agenda where we all signed up and can equally, eye to eye, discuss how do we going to get to these sustainable development goals, and not anymore with this kind of, well, there was somebody who knows or somebody who is in advance of development. So we can really talk about how to jointly get to these objectives. And the second one, for us, the most important is not so much the goals, but the principles behind the agenda. And we are very much focused and concerned about how to implement the leave no one behind principle, because we think, and particularly in this agenda as well that we discussed today, the leave no one behind is the key to success. How do we get really everybody on board? How do we reduce inequality? How can we make really everybody participate in the successes of hopefully development? So I think this is for us at least the most important driver. Coming back to my question, sorry Eduardo for this little co-commentary here, but the question on legitimate policy on the one hand, and prevention as well on this question, which we think is very important as well. So what is really the key driver for this agenda of prevention? Thank you very much for your attention.
Thank you very much for your question. We have a question from Christian Much.
Thank you very much, Christian Much. I have a question to Marieke Wierda regarding the conceptual framework at the United Nations for the work in the field of transitional justice. Before you joined the Dutch government, you've been working with a UN mission in Libya as a transitional justice advisor. So the question is, what was your conceptual framework in doing that? Was it a country-specific one, or was there a more general conceptual framework? how did you interact with UNDP in order to implement your measures? And what was their conceptual framework? Were they compatible? Were they identical? And lastly, a question, since you were one of the co-authors of the Nuremberg Declaration 10 years ago, what is it in that chapter on development that you would write differently today? Thank you.
Thank you, Christian. So I think we can start with the answers and we collect more questions later.
Thank you for your question. I cannot speak about the specific Ukraine situation because I really don't know it and we can talk about it afterwards. But typically what I would like to say is that we are not an organization providing training in the sense of classroom training. These are other organizations are doing that very well. We are not entering into that field. What we are doing is more, once a training has been provided, for instance, we can come and reinforce what has been discussed and taught in that training through this peer-to-peer mentorship that I described in my presentation. And typically what we do when we get a request like this, there is a number of criteria we are looking at to see whether a deployment is possible. One of them is whether the request for deployment is in conformity with international law. The requesting entity would have a mandate to do the investigation and so forth. The second is about, is there a political motivation that is dominating the agenda of the requester? That we don't want to have our expert instrumentalized into a political process, and we need to verify that aspect. The third element is security of the expert and the witness and or the people with whom he's going to enter into contact. That's the general conditions that we look at systematically for any type of deployment, and that guides our work to avoid instrumentalization and the rest. And now for a request like this, which enters into the field more of complementarity work that I described, we would look at political will. Is there an institution that is strong enough to pursue those procedures and investigative work? And finally, we look at the legal framework, whether they are there already to be able to pursue such crimes. And then once these different elements we are comfortable with them, then we would probably send a consultation mission to discuss with the counterpart and understand what is it actually that they need. If it was training, then we would probably refer them to a training organization, and I'm looking at Chris because that's the type of tool that they could be referred to, and then see how through mentoring and peer-to-peer support we could be supporting, but what the person who talked to you actually wants to have in terms of support. And then you asked a question about donors. That's always a difficult question because we have created an international fund for rapid deployment to which states can contribute so that we have money available to deploy rapidly without having to find the money between the moment the request is coming in and the deployment. But it's increasingly difficult to get this sort of unearmarked funding into that fund today. Then probably we would have to look for funding for that specific mission or the specific series of missions that would be necessary to do the mentoring program and the support to peer-to-peer support with the prosecutor. That's my long answer.
First, to thank my colleague from Germany for the insights into the policy here. And I think there's quite a lot of overlap between the way you're approaching things and the way we're looking at it too. We also have this integrated approach of what we call 3D, development, defense, and diplomacy. So we do a lot of interministerial work, but specifically on this concept of legitimate stability, we ended up drafting what we call a theory of change, about what is this concept. And at the heart of it, we put this issue of, in essence, siding with the citizen rather than the state. So in a sense, we seek, through our interventions, to improve the social contract between citizen and state, and that interpretation then colors the other dimensions of the strategy, which include human security, so not state security, but human security. From rule of law, it gives us this bottom-up perspective, but also putting, for instance, emphasis on transitional justice for past crime rather than only current crime situations. We then have an aspect of inclusive political processes, including mediation, but also peace building. And then a final component is also on economic reconstruction. So we have much the same. On the finance field, I think that's an excellent addition. Our minister has in fact often lobbied for stronger tax laws on the domestic front, but we haven't explicitly incorporated that into our policies. So this is very innovative. On the 2030 agenda, one comment I would like to make is that I think the universality is both a strength and a challenge. Because I think there is something about global indicators which can be perceived negatively by fragile states, because they often find themselves in the bottom of these lists, and they say the indicators are not developed with sufficient sensitivity to their local peculiarities. So what I would say, I think the universality, in finding these new partnerships, I think we have to give a lot of space to fragile states to set their own agenda, which could be far broader than what we've spelled out in the indicators of Goal 16. And one process through which this is happening is a New Deal process in the G7+, for instance. And I see quite a lot of potential there for fragile states to set their own agendas amongst each other and then to come back to us to say what they need to leave nobody behind. Because as we know, and this is something the World Bank has said as well, by 2030, 50 to 64% of poor people will be living in fragile and conflict-affected states. So that's the challenge for us. Libya and conceptual framework and transitional justice. I think the UN, of course, over the years has done quite a lot to spell out the transitional justice framework. So there was a report in 2004, one in 2010, etc. But the accusation has sometimes been that they adopt quite a technical approach, so it became very mechanistic. So we look for truth commissions, prosecutions, institutional reforms and reparations in every context. And I think that's not the idea. In Libya, in the end, what ended up dominating our agenda, of course, the ICC was involved, so that gave a lot of extra focus. But the justice minister at some point said, why does the international community care about 2 individuals when we have 6,000 in custody? And the acute issue that we had to face was illegal detention, so many people getting swept up, being accused of being Gaddafi supporters, and being held without legal framework, being interrogated by actors who are not judicial actors but militias, and all the abuses that resulted from that. One did see a nice integration between rule of law, human rights, and transitional justice. Those agendas are all very intertwined in those contexts. But I think ideally, one thing we would have done differently, and that where I see a big need for transitional justice actors, is also more this bottom-up approach. I think we need to know more about what people actually want in their own contexts. And for instance, in Libya, property issues are high on the agenda. In Syria, they may be as well. And so I think we need to gather data on that, and we need to use that data. I think we, as as practitioners from an international criminal law field, we have our presumptions about what we think people think are important, because that's what we call the core crimes. But I think we need to be open that we need to complement our interventions with responding to justice needs as identified by those affected.
I'd probably just re-emphasize the fact. Well, firstly, thank you for the question on prevention and this concept of legitimacy. I hope you will read the joint World Bank UN report on conflict prevention. We have Pathways to Peace. It's the companion report, the sort of 55-page report, which is the short version. We are now finalizing the 350-page version. We have received your guidelines, and it's considered in the report also. But it comes at it from a different way, right? So it considers legitimacy by starting with the demography, with the people, right? And then how do we obtain what the people, or identify what the people want, right? What are our methods for doing that? Who are we communicating with? And to what extent are those people authentically communicating a real representation of, the broader feeling amongst particular communities, right? And what's the diversity, and what are the common ground between the communities, right? And when you've identified that, to what extent are we competent? Do we have the capacity to then communicate how we got to our own understanding to the different communities about where the common ground is, right? Because we can do it, but then if we're not communicating, then you have that tension between the objectively being inclusive and being perceived to be inclusive, right? And this is, I think, this is where we don't have a lot of evidence, right, about how we do this, and this is the issue, and who we engage to mobilize political will behind us, right? Rule of law is a classic, right, where we come with our moral suasion, and we shouldn't stop doing that. It is powerful, but we go and we engage the civil society actors who say, you need to change the policy on, for example, on pretrial detention, right? Because these people should not be there without, without being charged, for months or even years at times. And they're right. But, now we're hoping to gather the data on the economic case, right? We want to engage with the business schools in New York to say, what is the cost? You're taking all these people out of the labor market. You're taking these people out of aggregate demand, and then building a robust methodology for calculating that, getting it out to our colleagues in the field so they can then communicate this to leaders of industry who, the reality is, have much more suasion when it comes to the executive in these countries, to our government interlocutors. Right, and this is where I think UNDP needs to, we need to take the next step, and if we can do it in collaboration with our government supporters, this would be particularly advantageous.
Thank you, Chris. We can discuss about prisons and in particular United States, because it's not simple. It's a business too, right? So that's why I put that face. Please, we have a question here and another question there, but first, Sarah, please.
Thank you to the panel. Natural resource exploitation and extraction is becoming a booming industry in a number of our countries, particularly in sub-Saharan Africa, in my country in particular. And we're seeing this to a certain extent contributing to the economy. However, with it obviously comes some serious human rights violations, whereby you have these huge multinationals coming in with the support of the state, times displacing populations without adequate and prompt compensation, to a certain extent triggering conflict, inter-community conflicts. So to what extent is the field of transitional justice ready to respond to these new emerging forms of conflict?
Thank you very much for your question. I'm happy.
Gurgen Petrosyan from Friedrich Alexander Langen Nuremberg University. I wanted to ask you, Samuel you mentioned about the political will of the states to cooperate with the international experts. I wanted to ask you if what is the first reaction of the domestic prosecutors and investigators to cooperate with them? Are they really happy to do that, or somehow how it is on the practical perspectives? Thank you very much.
Okay, one last question or two last questions. Bill Pace, please.
Thank you. My perception over these last few decades is that there has been a real wall between development, humanitarian assistance, and rule of law or human rights, international justice work. And that was structured into overseas development assistance laws, if you wish, policies. And in addition, that the kind of development leaders at the country level saw the work doing international justice or conflict prevention, etc., as both too politically controversial to get into, and secondly, that it was small beans. It was just too little. The grants for infrastructure, for education, for health, for agriculture were big, etc. Doesn't that continue to be a fundamental problem that we face with this whole issue of development and justice?
Thank you. Navi, please.
Just following from there, another very fundamental grievance, which I didn't hear the panel address, is that people in the developing countries suffer enormously from illicit trade and illicit flow of funds. The figure is now 80 billion a year leaving the continent of Africa each year. Far greater than what countries spend, say, on education or health in their own budgets, far greater than the development aid, all the development aid that comes into the country. The problems they identify with that is lack of cooperation from developed countries in sharing information, lack of cooperation in repatriating these funds, and lack of cooperation in loosening the financial secrecy measures. So I wondered if any of you are addressing that, whether it's addressed in these plans that I heard, the Netherlands and the German one and the World Bank UN one. Thank you.
Thank you, Navi. The last question, the lady behind. Yeah, please.
Thank you. My name is Gunhild Schüttaler-Ruf, also from GIZ. I would like to ask a question linked to the one Eduardo made at the beginning, and it's we now also have a strong focus, also since the World Humanitarian Summit, on the LRRD approach, so linking recovery, rehabilitation, and development. And I would like to, I still feel that there's some kind of resistance to this approach. And I would like to know whether you think TJ approaches of transitional justice might help to strengthen the LRD approach.
Thank you very much. Dear colleagues, we have 5 minutes, so good luck.
Right. So, yeah, emerging forms of conflict, natural resource exploitation. I think this is, this is something that perhaps international criminal law practitioners have been insufficiently innovative in considering how they might approach, right? And, and one thinks automatically to these issues of aiding and abetting. And there's a link between this first question on the, these emerging forms of conflict and, what might arguably be the most significant challenge to engaging on these issues of aiding and abetting, which is Navi Pillai's question about the opacity of international financial transactions, and of course you have the financial integrity group in the IMF, but the way they engage with countries is to assist them on developing, their own architecture to develop financial transparency. And of course, again, it comes back to a political economy question of the political will of that, or the interests of the actors in that government at a particular time, to shine a light on these kinds of issues. And when we have, like you say, the amount of aid provided totally dwarfed by the financial outflows, it renders impotent what we're doing. And then we go back to who is financing the aid. Often it comes from the very same economies that benefit from these financial outflows. And since we're here talking about international criminal law, I just wonder about the extent to which international criminal law practitioners are actually fully employing the discretion that they have, right? When we look at going after Thomas Lubanga, some commander from a Turi province, and who is passing the finance and the weapons, and often people will say, oh, well, we need to look across. Let me emphasize again, talking with my SILRAP hat on. People will say, oh, we need to look at Kagame and Museveni, and they're funding these actors. But no, we can look even further than that. Who have the concessions there, to extract the resources. And to what extent could we at least demand, in a public way, cooperation from those entities, to apply that kind of pressure. And this can even happen in a coordinated way, hypothetically at least, with governments, to strengthen their hand in demanding greater control and a greater share of the pie in this whole extractive process, and even go further, right, towards the value add, because this is really the common grievance. All the value add happens outside. You take the natural resources. The wall between development, human rights, and humanitarian actors, I think, also goes to this issue of the political economy. Who's financing? Who's and who benefits? And again, we see these linkages. They're not in law. They're informal, and and much of that, much of the driver is the opacity, and that's what we have control over, right? We in academia, or we in the practitioners.
Maybe very briefly just acknowledge the extent of those kinds of problems in development work. And the only thing I would add is that I do think there are some technological advances that can maybe help us in the future, particularly with financial flows, etc. I'm thinking of blockchain technology. But I, like you, am a lawyer, so please don't ask me to explain it. Maybe Google it in the break. But I think there are quite significant expectations that this will help us in financial transparency issues, at least when we deal with governments. The other two issues I will briefly address, this wall. I think it's a real issue still, Bill, but I think also it's in a way often structural. Many of us deal with international justice issues from our human rights and multilateral affairs departments, and we deal with development from our development departments, and so it's quite difficult sometimes to really build an integrated strategy. But I do think we have to seek to embed also international justice interventions better in development interventions, because otherwise they can appear a little bit disconnected. Example, a court in the ICD in Uganda really only trying one case, having no political will to look at government abuses, etc. And Uganda perhaps not even really being in having much political will to do transitional justice. So we need to embed those approaches. And then finally, on this issue of recovery, rehabilitation, development, and reluctance to integrate there, I think we're, in some situations we're encountering now, we're going to be forced to integrate our strategies there. And I'm thinking primarily of Syria. I think in Syria, one issue is the core crimes, and I want to stress again from my government, the mechanism that was created to look at that is very important. But we do see also as the next enormous challenge the issue of return. With that degree of displacement, and all the issues that are relating to that, I think will fall into that category and will force us to come up with integrated approaches to facing those challenges, which in many cases are also justice challenges.
I would just say that I keep my ears really wide open, because those topics that you discussed are really interesting and relevant, and the relevance of the roster that we are managing is only commensurate to how much we can stick to those issues and how much we can equip the roster with the type of expertise that you would need to address this type of new and emerging trends. It's not the case necessarily now, but we need to listen to what's needed out there. On the specific question of the mentorship, I hope you didn't have a negative experience, a negative mentorship experience yourself. What I would like to say in really 1 minute is that it depends on probably 2 or 3 things. The first one is whether you have been good enough at listening to what was needed for the person who should be supported. And we always start this mission with a consultation mission so that we understand what's needed. We don't want to impose an agenda or a specific case or a specific approach. The second is that it's going to be as good as the expert that you can deploy to support the person. And mentoring is not necessarily a given. I mean, some people are good at it, others are not. And the third element, which is a mitigating measure to the risk of not having the right person, is this support coming from experts who have themselves experienced the kind of material, time, and situations that are typical of post-conflict situation and transitional countries in transition. When you combine these 3 elements and you manage them, you have a pretty good result in terms of acceptance when you are deploying your people. If you neglect one of these 3 elements, there is a good chance that your guys is not going to be well received locally because they have no time, no means, and they don't see how they can relate to someone who has no understanding of a post-conflict situation.
Thank you very much. We are right on time. It's 10:30. Before I close this panel, I just want to announce we will continue with the next panel. So I'll ask Martin Klings to come here and take over the session. And we don't have break in this moment. We will have it after the next panel. So to conclude this, I would like to take the words of Marieke, who called for the 2027 meeting that we will have to analyze this again. And I would like to say that 2027 is tomorrow. It's not. We are going to meet in 10 days, a little bit older probably, but we will see that the time passed too fast. So we need to be aware of that and to work to have a better meeting in 10 years. So thank you very much.